Well, our reporter, Canny Maphanga, has more on this story. She's been following it closely. A very good afternoon, Canny. Tell us what's the latest.
Well, good afternoon to you, Nombu, and to the viewers at home. The matter is currently stood down until 3 p.m. That was to allow counsel to just deal with the outstanding filings that are needing, that is the replies, ahead of the matter being heard at 3 p.m. today in the Gauteng High Court in Pretoria. As it stands right now, Nombu, we do expect that this matter still remains on the roll and will be heard by Justice Select Pottrell at 3 p.m. when that matter proceeds. As you've correctly stated, the Speaker is seeking an urgent interdict which will block her arrest, and she's also seeking full disclosure of what documents the NPA, the ID, as well as SABC has in pursuing this criminal matter against her, which deals with corruption allegations during her tenure as Minister of Defence. Now, this is an unprecedented move to ask the criminal justice system to prove the strength of their case to you before you subject yourself to that process. But that is essentially what she is asking the court to do today. However, the first issue we can deal with in the court when those proceedings start is the question of urgency. Is this matter urgent? Will she suffer irreparable harm if it is not heard today and determined today? If the court decides that this matter is urgent, they'll then move to the merits, where the applicant's counsel will spell out the case, and then of course we expect the NPA to vehemently oppose the matter, arguing that it isn't urgent, the matter is a self-created urgency, and it's baseless, and therefore the matter should be dismissed.
So, Canny, what are the chances of her success in this regard? Because, like you say, it's unprecedented, and at the end of the day, she is, we're all supposed to be equal before the law.
Exactly, Nomku. Each case is determined on its own merits, so I don't want to delve into whether a court will decide for or against her application. But this issue that you are raising about all being treated before the law is what could risk a case like this. What she's essentially asking for, if you look at it at surface level, is quote-unquote a special treatment. Because if you and I were arrested, you would go through that particular process, you'd be processed at the police station, you'd make your first appearance, the matter would be enrolled, the charges would be listed to you, and you would only get that full disclosure that she is seeking when the matter is prepared to be transferred for trial. So you can imagine the kind of legal precedent this matter will be setting if she is given the relief that she is seeking here in the court and is allowed to ask the state to prove the strength of its case by giving her full disclosure ahead of the matter being heard or ahead of her subjecting herself to that criminal justice system. It would really topple what we've been used to in the criminal justice system, where people appear before courts all the time, they appear before the criminal docs, they defend themselves, the state presents their case, and the court makes a determination. That's just how the criminal justice system works. It's unprecedented that you can expect to hear the matter first or see the evidence before you subject yourself to that criminal doc.
Absolutely. Canny, we're going to leave it there, but thank you very much for your report there, Canny Maphanga.